Welcome to this in-depth analysis of contracts in Italian civil law. Contracts are one of the most important and widespread legal institutions, a fundamental pillar of economic and social relations. Understanding their structure, formation, and potential issues is essential for anyone working in the legal or business world. Our course will lead us through the general definition of a contract, its essential elements, the various forms of invalidity, and finally, the methods of termination. The goal is to provide a clear and professional guide useful for students, professionals, and the general public alike. A contract, in its most general sense, is an agreement between two or more parties. This mutual understanding is the cornerstone of every contractual relationship, demonstrating the united will of different parties. It is the convergence of interests and declarations that gives rise to a legal bond. The primary purpose of a contract is to establish, regulate, or terminate a legal financial relationship. This means that a contract can create new relationships, modify existing ones, or terminate existing ones, provided they have an economically valuable content. Financial status is a fundamental distinguishing feature. The fundamental function of contracts lies in their essential role in the circulation of wealth. They facilitate the exchange of goods and services, the granting of credit, and the implementation of investments, fueling the economy and trade. Without contracts, economic dynamism would be severely compromised. Ultimately, contracts are the preferred means for realizing private interests. They allow individuals and businesses to pursue their economic and personal goals, ensuring certainty and legal protection for their decisions. They are an expression of the parties' contractual autonomy. For a contract to be valid and produce legal effects, the law requires the presence of four essential elements. Their absence or unlawfulness determines the nullity of the contract, preventing it from being validly established in the legal system. These requirements are essential for its existence and functionality. An agreement is the meeting of the wills of the parties, the convergence of their declarations of intent. It represents mutual and informed consent on all aspects of the contractual provisions. Without this meeting of wills, the contract cannot be considered formed. The formation of an agreement typically occurs through the exchange of an offer and an acceptance. This sequential model is the most common, but not the only way to reach a contract. It is a dynamic process that culminates when intentions merge. An offer is an offer to conclude a contract, a unilateral declaration by which one party expresses their willingness to be bound by certain conditions. It must be complete, containing all the essential elements of the future contract, and demonstrate a serious intention to enter into a binding agreement. Acceptance is the acceptance of the offer, the declaration by which the offeree expresses their willingness to enter into the contract under the terms offered. It must be unconditional and unequivocal, expressing full compliance with the offer received. To be valid, an acceptance must meet specific requirements. First, it must conform to the offer in its entirety. Any modification or addition to the original offer does not constitute acceptance, but constitutes a new counter-offer, reversing the roles of the parties. Furthermore, acceptance must reach the offerer within a reasonable time frame or one established by the offerer. The contract is considered concluded at the time and place where the offerer becomes aware of the other party's acceptance. Timeliness is crucial to the certainty of the relationship. The cause of a contract is its economic and social function, the operation the parties intend to achieve through that particular contractual framework. It is not the individual and subjective reasons, but the objective and specific reason for which the contract is entered into. It is the summary of its essential legal effects. The purpose the parties intend to pursue through the contract must be lawful and worthy of protection under the legal system. The cause justifies the transfer of wealth and the assumption of obligations, giving the contract its legally relevant raison d'etre. A fundamental requirement for a cause is its lawfulness. The cause must comply with mandatory provisions, public order, and morality. A contract with an unlawful cause is void, since the legal system cannot recognize the validity of transactions that conflict with the fundamental principles of civil coexistence. The lawfulness of the cause implies that it must not be contrary to mandatory provisions, which are those that cannot be waived to protect general interests. It must not violate public order, which represents the set of fundamental principles of the legal system. Finally, it must not offend morality, understood as the set of ethical and moral principles shared by society. The object of a contract is the performance the parties undertake to perform, that is, the good or service the agreement covers. It may consist of a give, a do, or a refrain from doing, and represents the concrete content of the contractual relationship. It is what the parties exchange or undertake to provide. The object of the contract must meet specific requirements for its validity. It must be possible, lawful, determined, or determinable. The lack of any of these attributes renders the contract void, as it lacks valid and enforceable content. First, the object must be possible. Possibility can be physical if the performance is materially achievable or legal if it is not prevented by law. A commitment to perform something impossible cannot generate a valid legal obligation. Second, the object must be lawful. It must not be contrary to mandatory provisions, public order, or morality. A contract whose object is an illicit performance is void, since the law cannot protect prohibited or socially reprehensible activities. Finally, the object must be specific or determinable. It must be clearly and unequivocally specified at the time of entering into the contract, or the criteria for its future determination must be indicated. Uncertainty about the object prevents the formation of a serious and binding obligation. The form of a contract is the way in which the parties' intentions are externally expressed. It can be oral, written, or the result of conclusive actions. It is the external expression of the internal agreement, making it perceptible and verifiable. The general principle governing form in our legal system is freedom of form. The parties are free to choose the manner in which they express their consent, unless the law requires a specific form. This principle promotes the speed and simplicity of exchanges. However, there are exceptions to this principle where the law requires a specific form for the validity of the contract. These forms are called ad substantiam, and failure to comply with them results in the nullity of the contract. They are provided to protect public interests or the weaker party. A classic example of a specific form required by law is the written form for the sale of real estate. To transfer ownership of a property, the contract must be drawn up as a public deed or private agreement under penalty of nullity. This formality ensures certainty and transparency in the most important transactions. A contract is invalid when it is unable to produce its legal effects or produces them precariously. This is a condition that affects the contract from its inception due to defects present at the time of its formation. The main causes of invalidity are nullity and voidability. Nullity is the most serious sanction that can affect a contract, rendering it radically invalid from the very beginning. A void contract is considered by the legal system to have never existed. It protects general interests and fundamental principles of the legal system. The grounds for nullity are numerous and strictly provided for by law. Nullity occurs when one of the essential elements of the contract is missing, such as the agreement, the cause, the object, or the required form ad substantiam. The unlawfulness of the cause or object also determines nullity. A contract is also void when it is unlawful or contrary to mandatory provisions, public order, or morality. The legal system cannot recognize the validity of agreements that violate fundamental principles or mandatory prohibitions. Nullity serves to protect higher values. The effects of nullity are retroactive and absolute. A void contract produces no effect from the outset, as if it had never been stipulated. Any performance performed under it is void and must be returned. Nullity is imprescriptible and irremediable. Nullity can be declared ex officio by the judge, even without a specific request from a party. This underscores the public policy nature of nullity, which the judge is required to determine for the protection of the legal system as a whole. Anyone with an interest may assert it. Voidability is a less serious form of invalidity than nullity, which renders the contract enforceable but precariously so. A voidable contract is effective until challenged and annulled by the entitled party. It protects the specific interests of one of the parties. There are two main causes for voidability: the conclusion of the contract by an incapacitated person and defects in consent. Incapacity can be legal, as in the case of a minor or an interdicted person, or natural if the person was not capable of understanding and willing at the time of the contract. The defects of consent are error, duress, and fraud. Duress is a false representation of reality that induced a party to enter into a contract. Duress is a threat that forces a party to enter into a contract. Fraud is a deception that misleads the other party. The effects of voidability are that the contract remains in effect until challenged and annulled by a court ruling. The annulment ruling has retroactive effect, eliminating the effects of the contract from the moment of its conclusion. A voidable contract can only be challenged by the party whose interest is the cause of voidability. For example, only a person with limited capacity or a party whose consent has been tainted can seek annulment. The annulment action has a 5-year statute of limitations. After examining formation and invalidity, it's essential to understand what happens when a contract, even if validly formed, is broken or can no longer produce its effects. We're talking here about dissolution of the contract, which occurs primarily through termination or rescission. Termination of a contract is a remedy that occurs for reasons that arise after its conclusion, preventing the performance of obligations or altering the bilateral balance. It aims to dissolve the contractual obligation due to supervening events. Common causes for termination include non-performance by one party, subsequent impossibility of performance, and excessive burdensomeness. These events disrupt the proper functioning of the contractual relationship, justifying termination. Non performance occurs when one party fails to perform its obligations or performs them improperly. If the non performance is serious, the non defaulting party may seek termination of the contract, in addition to compensation for damages. A supervening impossibility of performance occurs when performance becomes objectively impossible for reasons not attributable to the debtor. In this case, the contract is automatically terminated and the release party cannot demand compensation. Supervening excessive burden occurs in contracts with continuous or periodic performance, or with deferred performance when extraordinary and unforeseeable events make a performance excessively burdensome for one of the parties. The disadvantaged party may request termination or revision of the conditions. The effects of termination are the retroactive termination of the contract between the parties. This means that any performance already performed must be returned, as if the contract had never existed. Termination does not affect any rights acquired by third parties. Rescission is a remedy aimed at terminating a contract concluded under conditions of imbalance due to the exploitation of one of the parties' state of danger or distress. It occurs when the contract was concluded under abnormal circumstances that have impaired contractual freedom. The cause for termination is a contract concluded in conditions of danger or financial hardship for one of the parties. In the first case, one party assumes obligations under unfair conditions to save themselves or others from grave danger. In the second, one party finds themselves in financial need and the other takes advantage of this. The fundamental prerequisite for termination is that the other party has exploited the situation of danger or need to gain an unfair advantage. There must be a disproportion between the performance and the other party's awareness of this weakness. The purpose of termination is to restore balance to the contract, eliminating the harmful effects for the injured party. The party who has suffered the damage can ask the judge to terminate the contract, restoring the parties to the situation prior to the signing. The ultimate goal of termination is to eliminate the harmful effects on the injured party, restoring contractual fairness. Termination proceedings are time barred 1 year after the conclusion of the contract. Validation of a terminable contract is not permitted. With this overview, we've explored the fundamentals of contracts in civil law, from their origins to their pathologies and termination mechanisms. Understanding these principles is crucial to navigating the complex world of legal and commercial relationships with awareness.